Chapter 3: Obligations and Contracts. Introduction. In this chapter, we will explore the obligation and contracts in legal relationships, and we will delve into the right and duties of parties involved in agreements and the legal implications of breach of contract. Definitions of obligations. An obligation is a legal duty to perform or not perform a certain act. It may arise from contracts, torts, or law. Understanding obligation is crucial for legal relationship and business transactions. Elements of a contract. A contract consists of an offer, acceptance, consideration, legality, and capacity. These elements form the foundation of a legally binding agreement. Understanding each element is essential for enforcing contracts. So we have the essential elements of contracts: consent, and next, subject matter or object. Consent, conformity of wills with respect to contracts, and object of contracts is the thing, right, service, which is the subject matter of the obligation arising from the contract. The object of obligation and the object of contract are identical. Next, we have the cause of contract. Is the why of the contract, the immediate and the most proximate purpose of the contract, the essential reason which impels the contracting parties to enter into it, and which explains and justifies the creation of obligation through such contract. Types of contracts. Contracts can be classified as express or implied. So, the express contracts, clear and explicit terms are communicated between the parties, legally valid and enforceable, intentionally and consciously entered into by parties, while the implied contract, not explicitly expressed in writing or verbally, also legally valid, but enforcing an implied contract may be more challenging due to the lack of written documentation, and it is created by default when the parties have dealings without explicitly stating their terms. Next, we also have these types of contract, which is the bilateral. A bilateral contract is a contract in which both parties exchange promises to perform. One party's promise serves as consideration for the promise of the other. We have the voidable or void contract. Voidable or void contract is a formal agreement between two parties that may be rendered unenforceable for any number of legal reasons, which may include failure by one or both parties to disclose a material fact, a mistake, misinterpretation, or fraud. Each type has distinct characteristics and legal implications that must be understood. Performance of contracts. The performance of a contract involves fulfilling the obligations and terms agreed upon by the parties. Understanding the obligation and duties of each party is crucial for successful contract performance. An example of performance-based contract would be a road maintenance contractor that is paid for the result of his work. If a contractor is tasked to fill potholes, their contract might be based on performance. If no potholes remain, they have fully met the performance expectations, and payment will be made as per the contract. Breach of contract. A breach occurs when a party fails to fulfill their contractual obligations. It can lead to legal consequences such as damages, specific performance, or cancellation of the contract. Understanding breach remedies is essential for legal protection. Example of breach of contract. For instance, if there is an agreement to buy a truck and the seller delivers a car, the buyer is excused from paying for the wrong vehicle. Impossibility and frustration. In some cases, impossibility or frustration may arise, making it impossible to fulfill the contract. Understanding this concept is crucial for assessing the impact on contractual obligations. Example of impossibility and frustration would be a manufacturing facility is destroyed by an earthquake, making it impossible to deliver products as contracted. Exception: a party affected by an unforeseen event cannot be bound to fulfill its contractual obligations if there is a force majeure clause in the contract explicitly relating to such events. Assignment and delegation. Parties may assign or delegate their contractual rights and duties to others. Understanding the rules and limitations of assignment and delegations is crucial for contractual relationships. Termination of contracts. Contracts can be terminated through performance, agreement, breach, or operation of law. Understanding the methods of contract termination is crucial for ending legal obligations. So, what is the procedure for termination of a contract? If a party decides to terminate the contract, written notice must be used for the termination. Once the party has established the reason for contract termination, they must notify the other party of their intentions. Contract disputes. Contract disputes may arise due to disagreements over terms, performance, or breach. Understanding the resolution methods such as negotiation, mediation, arbitration, or litigation is crucial for addressing the conflicts. What is the cause of contract dispute? One significant cause of contract dispute are ambiguous or incomplete terms, such as contracts lack clarity, fostering misunderstanding and disputes. In particular, vague phrasing may lead to disagreements over the interpretation of the agreement terms. Conclusions. Understanding obligations and contracts is essential for navigating legal relationships and business transactions. The knowledge of rights, duties, and legal implications is crucial for enforcing agreements and protecting against breaches. Thanks for listening. This is Rhea N. Ranario, BSHM 3A.